Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Literally not true.
I didn't ask you to interrupt me.
Is that correct?
Dati mihi Anglican priest, Reverend Latino. Oh, for crumb's sake.
Good afternoon. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Hope your lunch was absolutely fabulous. I spent a fair amount of mine out in the parking lot, or the driveway, looking at the car. Yay. Yeah, so the car happened. Let's see. Greeners, first in chat somewhere, Greeners. I can't find you, so sample user it is. Where you at? Where you at, Greeners? What happened to the car? Mrs. R.A. Went and picked up the groceries today. Picked up the groceries and found a pole. Greeners gave it to Josh. Josh! On your birthday! Josh, congratulations. You, my friend, are the internet owner. I trust Red Pen implicitly. If she says it, it's truth. So congratulations, Josh. The internet is all yours. You are, in fact, the owner of everything IP-related worldwide, or at least the problems associated with everything IP-related worldwide. So if you could get right on that, and in addition to your other duties, because this does not give you a break, just because it's your birthday, just because you have other mod things to do, does not mean you cannot... it doesn't mean you can just put those on the back burner. We expect the pins to work properly. We expect, all the regular stuff to happen, find good court cases for us, all of that, and keep track of the internet. So thank you very much. Appreciate that. Yes, Mrs. R.A., she got the groceries, and she also got the pole.
I was told counsel wanted to see me inside.
She was backing up, and the pole just came out of nowhere and grabbed her. At least the front quarter panel, driver's side. That's a close one. It's the one you should be able to see, quite frankly. I'm not pointing fingers of blame, but I realize the far side, I drive a big vehicle, it's a Yukon XL. It's basically a land yacht, right? It's huge. I can see hitting the far side, being like, misjudged the distance. It's so far away I couldn't tell. But it's right outside your window. You just have to look down, and that's it. And she tagged it. I guess the pole tagged us because we're the ones with the yellow paint. But the pole, good news, the pole is fine. The pole is fine. Mrs. R.A. is fine. That was my number one concern. And the groceries are fine. And other than that, the car can be fixed. So that's where we're at. Let's see. We are
In front of the Walmart.
Let me jump over here. That's not it. That's not it. That's not it. That's it. Okay. About to come back to lunch here right now from the Raul Valle trial. And we are expecting that when we get back from lunch, the jury's going to receive some instructions from the judge. Sadly, we're expecting the instructions to sound like because the judge's microphone is terrible, and she also doesn't talk into it. So there's that, and the instructions might take about half an hour. So it's going to be like half an hour of just, we've got to sit through it. I'll do the best we can to get the best audio we can, but it's just not. It's not good. It's not good. But the instructions include some important things the jury needs to consider, specifically the law when it comes to self-defense in Connecticut. This is very important. The elements of the charges the state needs to meet. That's very important. And, of course, the instructions for how they should go about deliberating and coming to a conclusion if they are so able. So all that is coming up here in just a minute. So let's get some audio. Let's get some video. There we go. And now I need it up here. this one.
Hear ye, hear ye, hear ye.
Let's do this one, shall we? There we go. No crackles on that one. Need to fix that. We've got some audio equipment that needs to be adjusted. All right, a couple people need to be recognized. We've got some new members who joined us, and thank you very much for that. First of all, Kelly H. gifted another membership at the start of this live stream. Thank you very much, Kelly. Appreciate your support of the channel. Very consistent, and it means the world to us. Thank you. Thank you. Charmaine Daughtry, welcome to the gallery. Thank you very much, Charlene. And Harleen Ann, welcome to the gallery. I forgot to mention, we had a gifting train during the closing arguments. I didn't want to interrupt by saying anything, but there's like 25, 30 gifts that were given out in batches of 5. Thank you to the amazingly wonderful, generous people who gave out those gifts and welcomed new people with a membership to the channel. That is just amazing. And of course, those who are new here today, welcome, welcome, welcome. Judge Audio is worst ever. It's probably one of the worst, especially for a courtroom that has decent audio. Now, the lawyers need to stay by the mics for it to be really be good, but it has decent audio, and the judges is pathetic. All right, let's see. Where are we at? It is straight up 2 o'clock, which means any minute now, any second now even, we expect the court to come back, and we will resume our coverage. Let's see here. 1, 2, 3. That's not it. Nope. Okay. Getting everything lined up. Sorry about that. Clickety click click click. All right, I know this is a case that has people divided on both sides of the issue, and that's great. That is great, but it also is probably a fairly good indication that the jury themselves are going to be similar to us. We generally do represent the jury quite well here in this community. So, Regina Crawford just gifted 5 more memberships. Thank you, Regina. Thank you, thank you. Hello, Queen of South Africa. Welcome. Good to have you here. Royalty in our presence. I hope there will be a verdict today, says Crochet Nana. I hope so as well. Have you ever done a demographic poll? From what I can gather, the majority of your members are women. Barb, YouTube gives me some information. Basically, non-identifiable general demographic information. But yes, we do have the fairer gender are represented in a greater number than the more coarse gender. Josh is announcing my presence. Welcome, Josh. Good to have you here. It's your birthday, Josh. We could do a poll, but I can tell you that about 85% of the viewers on the channel, according to YouTube, or according to the information you provided to YouTube when you signed up, are female. So, and most of the community is mature female viewers. So that's going to be over the age of 30. That's the majority, not all. We have a sizable population of younger people who watch this as well, so it's great. All right, standing mute member for 16 months, still reeling from the Koberger plea, but I hope everyone had a safe and happy 4th of. I hope everyone has a safe and happy 4th of July. I hope so as well. Standing mute, thank you very much for that. 16 months. Thank you. Women do love true crime. They have the brain for it. I mean, I'm not saying that men can't do this, but I think women by nature are able to take evidence that's presented, all the different pieces, and like have it in their head at the same time. Where men are more hyper focused about one thing or another. Mainly just one thing, but yeah, women are better at it. That's it. Yes, we are, says Chihuahua Mama. Yes, we are. Ricky, yeah, don't feel bad. We have plenty of wonderful, great guys here in the chat as well. Don't you find that interesting? I do. I find it interesting personally. I mean, we're interested in the same thing. like to announce myself for the record. Maddie, we're here. You're here. Welcome. I think Cynthia, I think you're right here. We don't know which way this is go, and it could go either way. It really could. First of all, I am not my mindset, my thought process, my reasoning doesn't necessarily match those of the jury in Connecticut. I grew up differently. I've got different life experiences. I'm associated with different laws being normal than what Connecticut has, and so I'm not a good indicator for what the jury is going to do up there. So I guess if we could just poll people in Connecticut, longtime residents or lifelong residents of Connecticut, then maybe that would be a better indicator. But it's all good. Did I hear we were mostly mature women? Yes. Like 85%. Proud Grizzly Diana. I've got to say, watching Josh and Gazella, please tell me I'm saying that right. I want to say it differently. I want to change your name for some reason. I don't know why. Some names I just struggle with, and hers is one. But watching them together on Wednesday, was that last night? That was last night. That was really cool to see them together, and her staying up to 2:00 in the morning and looking good doing it. Oh my goodness. Yes, she's smart. She's witty. She's incredibly good at what she does, and her breakdowns and analysis of a case really can't be beat. She does a great job. So, and big shout out to Josh. Oh my goodness, have you missed that? I'm Josh, not talking about you, Josh Hutchins, on our wonderful mod. I'm talking about Josh from Courtroom Confidential. Inked a deal with a major television network as a legal commentator, and did his first bit. Was up there in Idaho, in Boise, for the Koberger. Sorry, I wanted to say Karen Berger, but that's different, for the Koberger trial. So that is really awesome. Grizzly CC Rock. It was a great show. All right. What's the different definition for mature? Asking for a friend. It varies. It does vary. I figure it's a trap if I step into this one. Ginger, I can't answer this question. She's an amazing lady. She is incredible. And the fact that her husband was involved, like not a true crime lover, and wanted to follow the Brian Koberger bit. He's like, what is going on here? This is crazy. That was really cool. All right. Ricky's saying, standing with me, don't do it. It's a trap. Yeah. I was going with careful. Well spotted. I'm mature enough to recognize a trap when I see one. And that was a trap. All right. Well, we have just a moment. First of all, I need to put my knife away. It's a fake knife, but we won't need this until Koberger sentencing on the, what is that, 23rd? Is that going to happen? I think it's the 23rd. Okay. Where was I? We were going to say something else. Oh, well, we've got a minute. We've got a podcast coming up tonight on this channel. That means if you are free at 8 o'clock Eastern tonight, and by free, I mean have the ability to watch online without taking away from some of the other responsibilities you have, whether it be family or work or whatever else. Obviously, those come first. That's priority. Take care of you first. We'd love for you to join us at the podcast. It is the Not Relevant Podcast. It is a light-hearted look at funny things that have happened around the world, some on this channel, amongst us as friends. It is a live podcast where Thomas and myself, Thomas is Weather Watch, one of our great moderators as well. He's in Texas. I'm in North Carolina. We're going to talk about some funny things. And as case may be, my arm was twisted, and I got talked into eating some nasty jelly beans. And I cannot back out of it as much as I want to, because Thomas already did his part. And now, in good faith, I cannot skip my responsibility to equal what he did last week. So 22 of the nastiest jelly beans. They might be good. I mean, the odds are very low that all 22 are going to be good, but they might be good. I know Thomas had, it seemed like an inordinate amount of them be very tasty. Not sure about that. So 22 Not Relevant Jelly Bean Podcast. Bad things to follow. I have tongue scrapers. I have Tic Tacs. I have Listerine tabs. I have breath spray. I have all sorts of things to sort of get rid of the bad tastes. I might get watermelon. 22 watermelon. There's a hope. There's hope, but probably not. All right. Let's see. You would match him. Bad bet. It was terrible. And I think he knows more about the color of jelly beans than I do. So he was able to make choices by choosing based on the color. Mine are going to be selected for me by my children, who think it's really funny when I eat yucky things because I make them eat dinner, which they think is yucky. And so this is their revenge time for all the broccoli I've ever made them taste. And so that's going to be coming up tonight. Payback is terrible, as you know. I have a headlight. I have a headlight. It's actually a tail light, but let's see. We have, the odds are not in my favor. They're terrible. Ooh, pink courthouse. You got, let's see. Connie Munster, 1 more month until my pink courthouse. Best 23 months plus ever. Thank you, RA mods in chat. Connie, OG, welcome. An original goat here on the channel. That's what we go with, the OG, original goat. Thank you for your long-term support of the channel, and looking forward to that new courthouse next month for you. Return the tail light. Amazon would return it. I bought it on eBay. Unfortunately, Amazon did not have them, and I'd keep it anyway. Can you eat handfuls? 3 to 4 bad mouthfuls versus 22. Kids, I thought about this. I thought, what if I just did 22 and just down the hatch? But in all fairness, Thomas bit every one of his 22. And what happens if the first one I bite is a nasty one, and then I have to keep it in my mouth while I'm chewing the other 22? And then I think at that point also, even if all 22 of them were tasty, together they would be nasty. So I'm going to go with the individual on this one. Since you have teenage boys, what would you do in this same instance? Are you talking about the car accident Missouri got in over lunch? Or the jelly beans. I'd make them eat them. Roman ADCC, those beans are the worst. My family played years ago, and several of us were almost puking. Vomit flavor is the worst. Thank you. I'm really hoping to avoid that one. I may try to make a live just to watch. Good luck. Good luck. Happy 4th of July. Roman, thank you very much with the Roman numerals as well. You know what, Roman, my youngest son just learned Roman numerals. And he can read you could give him a huge long number, and he's he gets it. He's like, okay. I actually used him when we saw the text of the witness that had the tattoos on his arm. I paused it and had him look at it. He's like, oh, that is and he does it on his head. That's 72, 76. I'm like, yep, you're right. It is. He loves them. I still can't understand them. All right, good stuff. Cynthia, she's like, why would someone do that? Why would someone do this? I think it's meant as a prank, and I'm on the receiving end. So, all right, just moments away from court starting. Give us just a second, and we'll have the latest here. We're already patched in for audio and video. Okay. 2-8. Okay, we're good. Youngest boy may be a code breaker. He's a rule breaker, I can tell you that. He's the one we found out on the roof of our garage and the roof of our house, which is 30 feet up in the air. Because he just wanted to see if he could. 12-12 pitch, by the way. So steep roof. He's out there. Just want to see if he can get out there. Yes, the police have come to our door saying, is that your kid on the roof over there? I'm like, oh, yes, it is. Hey, come back in. We've had that knock on the door before. Mellow yellow. I'm not even going to click on it. Please tell me that is not an actual flavor. Oh, my goodness. I have to open these and see what actual flavors there are. The only problem is the the things inside, I think it has very small writing that I can't read. Somebody says, what is above your pickle play button behind you? Well, that is a camera. That's a camera. Let's see. Coming back here, not there, here. That works. Here. Yep, we've got all sorts of feeds going on. We're good. We're good. Pickle play button behind me is what I have. No gray beans. Skunk flavor is bad. Oh, you guys, please tell me these are not. Never heard of such a thing. Connecticut seal looks like the Judge Bev's court curtain. The same color. Pantoufle says, I bought regular Jelly Bellies to rewatch with Mom tomorrow. We did family guess the flavor as kids, but snuck in the Harry Potters when they came out. It was savage. My kids are doing the same thing when this is all over. They have the regular, still unopened. I will show you this is unopened. I have not swapped any of these out. They have the regular ones they want to try. And they're like, oh, yuck, I hope I don't get mango. I'm like, I will trade you. I'll trade you a mango for earthworm. But yeah, so it's going to be fun. Pantoufle, thank you very much for your support. That sounds funny. Let's see. I think we're supposed to be back already, and it's not. We're not here, so I wonder what the delay is. Aurora, we haven't decided exactly what we're going to go to next, mostly because I'm going to be gone for a few days next week. I'm going to be filming something up in Virginia, and so I don't want to get you guys into a trial that's really exciting and suddenly you're all hooked and then say, and see ya, and then leave. So we'll check and see what's available. We might have some small courts, some small trials that we watch for a couple days and then pick up another one or pick up that trial and catch up when I get back the week after. How long have they been deliberating? We have actually not started deliberation yet. The jury has been told they are not ready to deliberate because they have not been told the law and given the instructions from the judge yet. They have not been charged, is the official term. That charge is expected to come right here as soon as break is over. The judge will read them the law, the charge, the verdict forms, and the instructions on how to deliberate, and then they will start deliberating. When are you away? It's just me. I'm going to be gone Thursday, Friday, Saturday. I haven't heard from Judge Fleischer. Judge Fleischer, his YouTube channel. Judge Fleischer is the judge that often wore bow ties and would sometimes come down in what appears to be a very stern response to defendants, yelling at them and telling them he'd had it up to here, and if he had a hair for each of times somebody have said something. Anyway, he's a really funny judge, but the YouTube channel just got to be too big, and I think it did what a lot of judges who personally stream their stuff on YouTube find. And that it occasionally can run into problems with cases, whereas where justice is not achievable because of something that happened on the YouTube channel. So it becomes an issue in a case, and that happened for him. He said it just got too big, and so he shut it down. He does still stream, but he does it on a different website. We're allowed to stream it. We just haven't been there. It's a little bit harder to bring his stuff in than other stuff. Judges should turn off the comments then. The other channel is actually not his channel. That's just somebody who is restreaming purely his stuff. But his actual stream is done on a government page now, not on YouTube. So His court stream is still publicly available and broadcast is approved. So, Carol, yes, I'm going to be hiking in the heat and carrying my equipment. And by equipment, I mean I've got everything: laptops, wireless mics, multiple cameras. I think I'm taking a drone, huge battery packs, like 25-pound batteries and chargers, and all my gear. It's gonna be wild. Starlink. I'm gonna have everything going up there. All right, do you have enough cables? I have all the cables. Plum Awesome Puce says we're overdue for a Mr. and Mrs. Cooking stream. I think we are due another one. Mrs. RA needs to do. I think cinnamon rolls are on the agenda, but it's going to be at least 2 weeks, and it's probably not even going to happen till like August time period, because after I go up to Virginia, I've got just like a week off, and then I have to go to Idaho for a week. I'll be working that week, though. You're not going to miss anything. Judge Fleischer is offering the ability to contribute to his campaign. Seriously? Are you talking about his retention campaign? They don't really elect judges. Usually they get nominated or appointed, and then every few years they're up for retention, where the public gets to vote and say, should we keep this judge or get a new one? Josh, I have never seen it. Never seen Turtlebox speakers. I'll have to look into them. How do I buy Starlink? You can click this link if you want. If you happen to buy Starlink after clicking this link, both of us will get a free month. Full disclosure. I'm not affiliated with them anyway, other than that they will give me a referral free month if you purchase it. I will just say that I've used it, and I found it to be very, very useful and adequate for what I need to do on the road. It's not what I have at home. I've got 2 gig fiber at home, plus some backups. But is Starlink as expensive as DirecTV? Depends on the plan. The one I use, I need an unlimited plan, so I pay for a plan that allows me to roam anywhere in the country and have unlimited usage. So I pay $165 a month, which is a lot, but it allows me to go on road trips and have it work. Usually if you get Starlink for your residence, like at home, it's a much cheaper plan, and you can have smaller plans that don't have the unlimited cap, and find that it could be under $50 a month for what you need. Or I know there's a $10 a month plan for just minimal stuff. So. About Starlink on cruise ships, they jam all signals but theirs, so you have to pay to get anything. They must be in international waters when they do that, because that would be like major FCC violation. Jamming someone's signal, intentionally interrupting a signal. It's literally I think it's a felony. How much is Starlink for a month? I pay $145, but you can get it for as little as $10 a month for a smaller package. Can you use Starlink at a house? The one I have, I can use anywhere. I literally have a battery, a magnet mount I can stick on the roof of my car and use it while I'm driving. I can set it up at any house I go. When I've used it at an Airbnb, where we set up there, you can use it anywhere. Maybe a felony, but you can plea down to double parking with the FCC. This is sadly, I think, true. Becca, I think she'd be happy with that. She probably could do everything she wants to do with a plan that's less than $50 a month. Does inclement weather interfere with the signal like DirecTV? Rosemary, great question. It can. The reason why the receiver is recommended to be on a slant is so that water will run off, because too much water just pooling on the top could cause a problem with the signal. Too much snow built up could cause a problem. That's why it has an internal heater. Like it literally can detect snow and warm itself up so that the snow falls off. And it needs a clear view of the sky. So if you were to drive under, say, like trees that the branches reached over and covered the road, you know those sort of tunnel roads, it would lose signal as soon as the branches cover it. It does need a clear view of the sky. Can Starlink be month to month? Yes. I turn mine off when I don't need it, and then I just turn it on the months I do. So I've had it on. I had it on last month. I have it on this month, but I'll probably turn it off in August. I don't think I'll need it then. Greeners. You can also rebroadcast Major League Baseball with implied oral consent from international. I would not take that as legal advice, everybody. Greeners means well, but yeah, that might not work. I've never had a problem with clouds. We ran Starlink in a heavy storm driving through, I think it was Tennessee, like heavy rain, and it worked beautifully. What's taking so long? I do not know. I think we might be starting here in just a moment, though. Let's see. I don't know why we're taking so long to come back. Did have tree problems. Trees were an issue. Starlink is a backup for Comcast. I hear you there. I have 3 internet services, and arguably a 4th, because well, this is the only thing I do. I don't have any other jobs that would provide for the family, and so if the internet goes down, they turn the lights off because they can't pay the bills. So we do depend on the internet being up, and I have 4 different avenues to live stream. If fiber goes down, or Starlink goes down, or cellular unlimited internet hotspot goes down, I still have an extra way to go up to get my signal out. So Starlink would not be a good choice for cabin in the woods. It probably could. I would just say that if your cabin in the woods is completely surrounded by trees, meaning the cabin's in shade, then you'll have a hard time getting a good signal. You might, but if you have a clearing, which oftentimes a cabin does because it provides fire protection, so you probably can get a mount up on the edge of your cabin roof that just is like roof level and has plenty of view from the sky, and it'll work great. Does this work even if you have no power, right? The Starlink does require power, so it has to be powered, but you can run that off a 12-volt battery. So if you have solar backup, that would work. If a lot of them can run off a cigarette lighter plug, or most battery packs, like the handheld battery packs, are 2. Even some of these, like this one here, this let's see. This guy here, this Anchor battery pack, which is a nice heavy-duty one. I think it's like 26,000 milliamp or something. Not strong enough to run the Starlink. The Starlink does draw quite a bit of power, but there are a few out there that can. Like if you have a Jackery, one of those emergency portable handhelds, there's a handle, it's like a little mini suitcase, that will run my Starlink for like 18 hours. Judge said she needed to do administrative duties. Kids are acting up, I'm guessing. All right. Can you attach to solar panels? Yes. You would want the battery. You wouldn't want the Starlink to be run directly off a solar panel. The solar panel should charge the battery, and the battery would run the Starlink. That way, when the clouds go over, it doesn't just cut off your signal, because it does take about a minute to once it's powered up to locate the satellites and perform that connection. What's happening in court? Nothing yet. They're still on lunch break. We're waiting for them to come back. The judge is taking care of business elsewhere. Did you have to pay $2,000 for the hardware? When I paid for it, I think it was like $400 or $500. They've now dropped the price to $399, plus they give you a $100 credit on your first bill. So the Starlink Mini is much cheaper now to install, and it can be month to month. What size Jackery? The Jackery I have is a, might be able to show you. It is an Explorer 1000, and I think it can run my laptop, which is a MacBook Air. Okay, so it's a low-power MacBook Air, and my Starlink. I think it runs both of them nonstop for 18 hours or something like that. Future says they put in fiber in my neighborhood a year ago or so. I'm thinking we need to switch to that. We have an extender in our house, and I still have trouble with sometimes on that side. Fiber is beautiful. One thing I like about fiber is a lot of communities that have fiber have a plethora of companies that are allowed to use that fiber backbone and compete against each other, so it drives the cost down. The plan I'm on right now with fiber I thought was great when I signed up for it. Now there are companies that are offering the same thing for almost half what I'm paying, so I might switch and you get a cheaper plan. Can you call my husband and tell him to switch? I could call, but that's best a decision you guys make together. I don't want to get in the middle of that. I would say if you have the ability to use fiber internet, like if it's installed in your area, and you rely heavily on the internet, say you use it for your work, or you use it to upload large files frequently, or you use it as your sole source of communication and entertainment. Fiber's working.
Good afternoon, Your Honor. Good afternoon, Your Honor.
Counsel, the court is prepared to charge in accordance with the jury charge that's been provided, which does reflect the changes that were discussed during the formal charging conference. The only additional change that's been made is adding some language regarding the actions of the lawyers during the trial, in addition to their statements, and just some typographical errors, maybe a comma here and there, grammatical things. That's about it.
Commas matter.
So I am prepared to move forward on this. I intend to take a break during the charge because, unfortunately, this charge is a rather lengthy charge. So I do want to provide the jury a few minutes to stand up and stretch. It's going to be difficult for everyone to get through just sitting. So I will give them some time to do that. We'll take a quick break in between. Additionally, I had asked about an exhibit list going in with the jury during deliberations. So I will be asking you to take a look at that, make sure that you agree that there's nothing on the list that you feel inaccurately represents the exhibit as an exhibit that provides concern to you one way or the other regarding whether or not that list should go in. So you'll have additional time to do that after the court's done charging. Is there anything that the court needs to address at this time?
No, Your Honor. Not from the defense, Your Honor.
All right. Very good. So I am going to go ahead and bring the jury in then. Thank you. I just want to, actually, give me one moment. I'm so sorry. I just want to address everyone in the courtroom. You're welcome to be here. There are some courts that close the doors, don't allow anyone in and out of the courtroom during the judge's charge to the jury. I do not do that. However, I am going to ask for your cooperation in staying and remaining in place during the court's charge to the jury. This is a very important part of the trial. This is the law that the jury has to apply to the facts they find. If you do have to leave the courtroom, I am going to ask you to respect the court and the process enough at this point in time to not return to the courtroom during the court's charge. I will be taking a break during the charge, okay? If it's an emergency that requires you to leave and you have to come back in, that's fine, but I am going to be asking the marshals to keep an eye on that, people coming in and out, okay? So if you have to leave, that's fine. Just please be cognizant of where we are in the proceedings if, in fact, you're attempting to come back in. I want the least amount of distraction to the jurors at this time. Thank you for your cooperation. But now,
all right, so the judge gave us a warning. I'm going to turn it down just a little bit here while we wait for this. Her mic is working a little bit better. She seems to be talking into it. That always helps, but it is still a terrible mic. She's got a lengthy instruction or charge to read, as there are multiple charges, lesser included. A lot to go on here. I'm guessing it's going to be over an hour. So we are going to get a break during this, probably when the first juror starts to nod off. That's probably when she's going to call the break. But this is the last step the jurors need before they can start deliberating. So let's welcome them in, and we'll do the best we can with the audio. Hopefully it'll get quiet once everybody gets settled down. All the table noise is a little irritating.
welcome back, ladies and gentlemen of the jury. Counsel, please stipulate to the trial.
State will stipulate, Your Honor. Defense stipulates, Your Honor.
All right. So once again, if you brought in notepads, I am going to ask you to set them aside. This is the jury's instructions. So I am going to instruct you on the law that is to apply to the facts you find in this case. You will have a copy of the court jury charge with you during the deliberations. This is going to be rather lengthy, so I do intend to give you a break during the course of my charge so that you can get up, stretch, use facilities, and sort of, get comfortable and be seated again for some period of time. So you have heard the evidence presented in this case. I am now going to instruct you as to the law that you are to apply in this case. During these instructions, I will, for the most part, be reading from prepared material. I do this so that I do not inadvertently give you incorrect instructions. So if I lose eye contact with you from time to time, please bear with me. The reading of these instructions, like I said earlier, is going to take some time. The function of the court and jury. It is exclusively the function of the court to state the rules of law that govern the case with instructions as to how you are to apply them. It is your obligation to accept the law as I stated. What I tell you, not what the attorneys tell you, is the law that you are to follow. If the law, as I give you, differs in any way from the claims of law made by counsel, dismiss from your minds what counsel have said to the extent it differs from what I tell you. You must follow all my instructions and not single out some and ignore others. They are all equally important. Also to note, in these instructions, the court does use the terms first count and count 1, second count and count 2, third count and count 3, fourth count and count 4, crimes and offenses, and information and substitute information interchangeably. You as jurors are the sole judges of the facts. It is your duty to find the facts. You are entitled in the course of evaluating the evidence to draw any and all inferences that you find reasonable and logical from the evidence you hear. You are to recollect and weigh the evidence and form your own conclusions as to what the ultimate facts are. You may not go outside the courtroom or the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or suspicion. And you must not be influenced by any personal likes or dislikes, opinions, prejudices, or sympathy. You should not be influenced by my actions during the trial in ruling on motions or objections by counsel, or in comments to counsel, or in questions to witnesses, or in setting forth the law in these instructions. You are not to take my actions as any indication of my opinion as to how you should determine the questions of fact. If I asked any questions of witnesses, you must not assume that I hold an opinion on the matter to which my questions may relate. Remember that you, as jurors, are at liberty to disregard all comments or questions of the court and the witnesses' responses to those questions in arriving at your own findings of the facts. You must not take anything I said or did during the trial as indicating what I think the evidence or what your verdict should be. Any reference I make to the evidence is only for the purpose of clarification of some point of law or a point of illustration, or to refresh your recollection as a general nature of the testimony. I do not intend to emphasize any evidence I mention or limit your consideration to it. If I do not mention certain evidence, you will use the evidence from your recollection. If my recollection of the evidence does not comport with your recollection, then it is your recollection which must prevail, because you are the exclusive trier of the facts. The defendant justly relies upon you to consider carefully his claims, to consider carefully all the evidence, and to find him not guilty if the facts and the law require such a verdict. The defendant rightfully expects fair and just treatment at your hands. At the same time, the state of Connecticut and its people look to you to render a verdict of guilty if the facts and the law require such a verdict. The law prohibits the state's attorney or defense counsel from giving personal opinions as to whether the defendant is guilty or not guilty. During my instructions to you, I may repeat certain instructions. I apologize in advance. I do this for the purpose of organization. You are not to consider a repeated instruction more important than any other instruction. All instructions are equally important. Also, during my instructions, I may refer you to previous or subsequent instructions given. When I do this, I will identify it for you and direct you to the section to which I am referring. If there is an inconsistency in the number and the title of an instruction to which you are referred, it is the title of the instruction that shall be controlling in my reference to it. Presumption of innocence. In this case, as in all criminal prosecutions, the defendant is presumed to be innocent unless and until proven guilty beyond a reasonable doubt. This presumption of innocence is with the defendant when he was first presented for trial in this case. It continues with him throughout the trial unless and until such time as all evidence produced here and the orderly conduct of the case, considered in the light of these instructions of law and deliberated upon you in the jury room, satisfies you beyond a reasonable doubt that he is guilty. The presumption of innocence as to each crime charge and as to any lesser included offense as instructed by the court may be overcome only after the state introduces evidence that establishes the defendant's guilt beyond a reasonable doubt. If and when the presumption of innocence has been overcome by evidence proving beyond a reasonable doubt that the accused is guilty of a crime charge or any applicable lesser included offense as instructed by the court, then it is the sworn duty of the jury to enforce the law and render a guilty verdict. Burden of proof. The state has the burden of proving that the defendant is guilty of the crimes with which he is charged or a lesser included offense as instructed by the court. The defendant does not have to prove his innocence. This means that the state must prove beyond a reasonable doubt each and every element necessary to constitute a crime charge or lesser included offense as instructed. Whether the burden of proof resting upon the state is sustained depends not on the number of witnesses nor on the quantity of testimony, but on the nature and quality of the testimony. Please bear in mind that one witness's testimony is sufficient to convict if it establishes all the elements of a crime beyond a reasonable doubt. Reasonable doubt. The meaning of reasonable doubt can be arrived at by emphasizing the word reasonable. It is not a surmise, a guess, or mere conjecture. It is not a doubt raised by anyone simply for the sake of raising a doubt. It is such a doubt as in serious affairs that concern you, you would heed. That is, such a doubt as would cause reasonable men and women to hesitate to act upon it in matters of importance. It is not hesitation springing from any feelings of pity or sympathy for the accused or any other person who might be affected by your decision. It is, in other words, a real doubt, an honest doubt, a doubt that has its foundation in the evidence or lack of evidence. It is doubt that is honestly entertained and is reasonable in light of the evidence after a fair comparison and careful examination of the entire evidence. Proof beyond a reasonable doubt does not mean proof beyond all doubt. The law does not require absolute certainty on the part of the jury before it returns a verdict of guilty. The law requires that, after hearing all the evidence, if there is something in the evidence or lack of evidence that leaves in your minds as reasonable men and women a reasonable doubt as to the guilt of the accused, then the accused must be given the benefit of that doubt and acquitted. Proof beyond a reasonable doubt is proof that precludes every reasonable hypothesis except guilt and is inconsistent with any other rational conclusion. Evidence. The evidence from which you are to decide what the facts are consists of 1. The sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. 2. The exhibits that have been received into evidence as full exhibits, including any pictures, videos, or documents that have been marked as full exhibits. 3. Any facts that the court judicially noticed. And 4. Any stipulation of the parties. In reaching your verdict, you should consider all the testimony and full exhibits admitted into evidence. Certain things are not evidence, and you may not consider them in deciding what the facts are. These include 1. Arguments, statements, and questions by lawyers. The lawyers are not witnesses. What they have said in their closing arguments is intended to help you interpret the evidence, but it is not evidence. Likewise, any emotion, reenactment, or other actions displayed by counsel during this trial is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, your memory of them controls. It is not proper for the attorneys to express their opinions on the ultimate issues in the case or to appeal to your emotions. Also, attorneys have a duty to object when they believe a question is improper under the rules of evidence. You should not be influenced by the objection or by the court's ruling on it, and you are not to hold it against any party for making objections. During the course of the trial, you may have heard counsel stand up and make comments about questions made by opposing counsel. You are not to regard any comments that counsel may have made in your deliberations. Any comments on the propriety of questions are not proper for trial or your consideration and should not be used in your deliberation. Lastly, the questions the lawyers ask of witnesses are not evidence. It is the testimony of the witnesses in response to the attorney's questions that is evidence. 2. Testimony that has been excluded or stricken. If I have excluded certain testimony, you must follow my instruction to disregard the testimony. In effect, I'm telling you to do what may be difficult, but which you will have to do your best to accomplish, and that is to accept in your minds that such stricken testimony is not evidence and must not be considered in your deliberations. 3. Anything you may have seen or heard when the court was not in session. 4. Anything you may have seen or heard from any spectators during the trial. 5. The document called the substitute information, which you will have with you at the time of your deliberations. The information is merely the formal manner of accusing a person of a crime to bring that person to trial. You must not consider the amended information as any evidence of the guilt of the defendant or draw any inference of guilt because he has been charged with crimes. You will note that each count in the information contains within it the alleged date and location of the offense. The state does not have to prove the exact time, date, or location of the offense beyond a reasonable doubt. However, the state must prove each element of each offense, including identification of the defendant, beyond a reasonable doubt. Direct and circumstantial evidence. There are generally two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence. That is, evidence from which you could find that another fact exists, even though it has not been proved directly. There is no legal distinction between direct and circumstantial evidence as far as probative value. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any particular evidence. Circumstantial evidence of an event is the testimony of witnesses as to the existence of certain facts or evidence or the happening of other events from which you may logically conclude that the event in question did happen. By way of example, let us assume that it is a December night and you're preparing to retire for the evening. You look out the window and you see it is snowing. You wake up the next morning, come to court, and testify that the night before it was snowing in the area of your house. That is direct evidence of the fact that it snowed the night before. You saw it, and you came to court and testified to that fact. Now assume that it is another December night, the weather is clear, there is no snow on the ground, and you retire for the evening. You wake up the next morning, you look out the window, and you see snow on the ground and footprints across your lawn. You come into court and you testify to those facts.
Cat footprints.
The evidence that the night before there was no snow on the ground and the next morning there was snow on the ground and footprints across your lawn is direct evidence. That direct evidence, however, is circumstantial evidence of the fact that sometime during the night it snowed and that sometime thereafter someone walked across your lawn. The only practical difference between direct and circumstantial evidence is that when you have direct evidence of some fact, the main thing you have to do is determine the believability of the direct testimony given, the credibility of the witness. With circumstantial evidence, you must first determine the credibility of the witness or witnesses and decide whether the facts testified to did exist. Then you must decide whether the happenings of those events or the existence of those facts leads logically to the conclusion that other events occurred or other facts exist, and ultimately whether the crimes alleged were committed by the accused. There is no reason to be prejudiced against evidence simply because it is circumstantial evidence. You make decisions based on circumstantial evidence in the everyday affairs of life. There is no reason why decisions based on circumstantial evidence should not be made in the courtroom. In fact, proof by circumstantial evidence may be as conclusive as would be the testimony of witnesses speaking on the basis of their own observation. Circumstantial evidence, therefore, is offered to prove a certain fact from which you are asked to infer the existence of another fact or set of facts. Before you decide that a fact has been proved by circumstantial evidence, you must consider all the evidence in light of reason, experience, and common sense. Redacted exhibits. If there are exhibits that have been accepted into evidence as redacted versions of the original, please note that these redactions were made by way of agreement by counsel or by order of the court, and you must not speculate as to why the information was redacted or what was redacted. Redacted information is not evidence, and as indicated earlier, you may not go outside the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or speculation. Credibility. In deciding what the facts are, you must consider all the evidence. In doing this, you must decide which testimony to believe and which testimony not to believe. You may believe all, none, or any part of any witness's testimony. In making that decision, you may consider a number of factors, including the following. 1. Was the witness able to see or hear or know the things about which that witness testified? 2. How well was the witness able to recall and describe those things? 3. What was the witness's manner while testifying? 4. Did the witness have an interest in the outcome of this case or any bias or prejudice concerning any party or any matter involved in the case? 5. How reasonable was the witness's testimony considered in light of all the evidence in this case? And 6. Was the witness's testimony contradicted by what that witness has said or done at another time, or by the testimony of other witnesses, or by other evidence? If you think that a witness has deliberately testified falsely in some respect, you should carefully consider whether you should rely upon any of that witness's testimony. In deciding whether to believe a witness, keep in mind that people sometimes forget things. You need to consider, therefore, whether a contradiction is an innocent lapse of memory or an intentional falsehood. And that may depend on whether that contradiction has to do with an important fact or with only a small detail.
This helps
These
the
are
defense.
some of the factors you may consider in deciding whether to believe testimony. The weight of the evidence presented does not depend on the number of witnesses. It is the quality of the evidence, not the quantity of the evidence, that you must consider. Witness with a cooperation agreement. You have heard evidence that witnesses Jack Snyder and Tyler De Silva have signed a document entitled Cooperation Agreement with the state, the terms of which are contained in States Exhibit 94 and 96, respectively. These agreements are permissible, and the rules of court provide for their use. Although the state is permitted to present the testimony of someone who has signed a cooperation agreement in exchange for his testimony, you must examine the testimony of such a witness who provides evidence against a defendant with greater care and caution than the testimony of an ordinary witness.
I like that instruction.
While examining the testimony of a witness who has signed a cooperation agreement and who has not been prosecuted with offenses for which the state has evidence, you should keep in mind that he may, in his own mind, be looking or hoping for some favorable treatment in the disposition of his own matters. Therefore, may have such an interest in the outcome of this case that his testimony may have been colored by that fact. In considering the testimony of such a witness, you may consider whether there was any motive developed in the evidence for testifying falsely in inculpating the accused. The factors you may consider, among others, when evaluating the credibility of such a witness include the extent to which the witness's testimony is confirmed by other evidence, the specificity of the testimony, the extent to which the testimony contains details known only by the perpetrator of the alleged offense, the extent to which the details of the testimony could be obtained from a source other than the defendant, the circumstances under which the witness initially provided information supporting such testimony to law enforcement or a prosecutorial official, whether the witness has received a benefit or expects to receive a benefit, including immunity from prosecution, leniency in prosecution, leniency in sentencing, or personal advantage in exchange for testimony, and whether the witness has ever changed his testimony. Further, notwithstanding any language contained in Exhibits 94 and 96, the cooperation agreement signed by Jack Snyder and Tyler De Silva, respectively, it is your exclusive role to determine the credibility and believability of that witness. In other words, you and you alone are to determine whether any evidence offered by Jack Snyder or Tyler De Silva is to be believed wholly, partly, or not at all, irrespective of any language in the cooperation agreement that may suggest otherwise. The determination as to whether the state has proven the elements of the crimes charged beyond a reasonable doubt rests solely with the jury after a careful examination of all the evidence presented. You should carefully scrutinize the testimony of Jack Snyder and Tyler De Silva before you accept it. However, you are not required to disbelieve a witness because he has signed a cooperation agreement. The law recognizes that there are many offenses that are of such character that the only persons capable of giving useful testimony are those who are themselves implicated in the crime. Like all other questions of credibility, this is a question for you to determine based on all the evidence presented to you. It is your duty to decide what credibility to give to any witness. Therefore, it is your duty to decide whether Jack Snyder and Tyler De Silva are to be believed wholly, partly, or not at all. Testimony of police officials. Police officials have testified in this case. You must determine the credibility of police officials in the same way and by the same standards as you would evaluate the testimony of any other witness. The testimony of a police official is entitled to no special or exclusive weight merely because it comes from a police official. You should recall the police official's demeanor on the stand and manner of testifying and weigh and balance just as carefully as you would the testimony of any other witness. You should neither believe nor disbelieve the testimony of a police official just because he or she is a police official. Expert testimony. In this case, certain witnesses have taken the stand, given their qualifications, and testified as expert witnesses. A person is qualified to testify as an expert if he or she has special knowledge, skill, experience, training, or education sufficient to qualify him or her as an expert on the subject to which the testimony relates. An expert is permitted not only to testify to facts that he or she personally observed, but also to state an opinion about certain circumstances. This is allowed because an expert from experience, research, and study generally has a particular knowledge of the subject of the inquiry and is more capable than a layperson of drawing conclusions from facts and basing an opinion on them. An expert witness may state an opinion in response to a hypothetical question. A hypothetical question is one in which the witness is asked to assume that certain facts are true and to give an opinion based on those assumptions. The value of the opinion given by an expert in response to a hypothetical question depends upon the relevance, validity, and completeness of the facts he or she was asked to assume. The weight that you give to the opinion of an expert will depend on whether you find that the facts assumed were proved and whether the facts relied on in reaching the opinion were complete or whether material facts were omitted or not considered. Like all other evidence, an expert's answer to a hypothetical question may be accepted or rejected in whole or in part according to your best judgment. In this case, you were provided expert testimony by the following witnesses: Dr. James Gill, Dr. Ryan Doss, PA Eric Black, and Dr. Roselle Crombie. Allowing someone to give expert testimony is in no way an endorsement by the court of the testimony or the credentials of the witness. Such testimony is presented to you to assist you in your deliberations. No such testimony is binding upon you, and you may disregard the testimony, either in whole or in part. It is for you to consider the testimony with the other circumstances in the case and, using your best judgment, determine whether you will give any weight to it, and if so, what weight you will give to it. The testimony is entitled to such weight as you find the expert's qualifications in his or her field entitle it to receive, and it must be considered by you, but it is not controlling upon your judgment. You are also to consider his or her general credibility in accordance with the instruction on credibility applicable to all witnesses. Defendant's testimony. In this case, the defendant testified. An accused person having testified stands before you just like any other witness. He is entitled to the same considerations and must have his testimony tested and measured by you by the same factors and standards as you would judge the testimony of any other witness. You have no right to disregard the defendant's testimony or to disbelieve the defendant's testimony merely because he is accused of committing multiple crimes. Consider my earlier instruction on the general subject matter of credibility and apply them to the defendant's testimony. Proximate cause. Proximate cause does not necessarily mean the last act or cause or the act and point in time nearest to the death or injuries. The concept of proximate cause incorporates the principle that an accused may be charged with a criminal offense even though his acts were not the immediate cause of the death or injuries. An act or omission to act is a proximate cause of the death or injuries when it substantially and materially contributes in a natural and continuous sequence, unbroken by an efficient intervening cause to the death or injuries. It is a cause without which the death or injuries would not have occurred. It is a predominating cause, a substantial factor from which the death or injuries follow as a natural, direct, and immediate consequence. It does not matter whether the particular kind of harm that results from the defendant's act be intended by the defendant. When the result is a foreseeable and natural result of the defendant's conduct, the law considers the chain of legal causation unbroken and holds the defendant criminally responsible. Specific intent. Specific intent is the intent to achieve a specific result. A person acts intentionally with respect to a result when his conscious objective is to cause such result. What the defendant intended is a question of fact for you to determine. The concept of specific intent applies to count 1, murder and manslaughter in the first degree intentional as a lesser included offense, count 2, assault in the first degree intentional and assault in the second degree intentional as a lesser included offense, count 3, assault in the first degree intentional and assault in the second degree intentional as a lesser included offense, and count 4, assault in the second degree intentional. Recklessness. A person acts recklessly with respect to a result or to a circumstance described by a statute defining an offense when the defendant is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstance exists. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. The standard of conduct of a reasonable person in the same situation as the defendant is the doing of something that a reasonably prudent person would do under the circumstances, or omitting to do what a reasonably prudent person would not do under the circumstances. A gross deviation is a greater substantial deviation, not just a slight or moderate deviation. There must be a great or substantial difference between, on the one hand, the defendant's conduct in disregarding a substantial and unjustifiable risk, and on the other hand, what a reasonable person would have done under the circumstances. Whether a risk is substantial and unjustifiable is a question of fact for you to determine under all the circumstances. The concept of recklessness applies to count 1, manslaughter in the first degree, reckless as a lesser included offense. Count 2, assault in the first degree, reckless as a lesser included offense, and assault in the second degree, reckless as a lesser included offense. Count 3, assault in the first degree, reckless as a lesser included offense, and assault in the second degree, reckless as a lesser included offense. And count 4, assault in the second degree, reckless as a lesser included offense. Evidence of intent. What a person's intention was is usually a matter to be determined by inference. No person can testify that he or she looked into another's mind and saw therein a certain knowledge or a certain purpose or intention to do harm to another. Because direct evidence of a defendant's state of mind is rarely available, intent is generally proved by circumstantial evidence. You will refer to the court's earlier instruction on direct and circumstantial evidence. The only way a jury can ordinarily determine what a person's intention was at any given time is by determining what the person's conduct was and what the circumstances were surrounding that conduct, and from that infer what his or her intention was. To draw such an inference is the proper function of a jury, provided, of course, that the inference drawn complies with the standards for inferences as explained in connection with my instruction on circumstantial evidence. The inference is not a necessary one. You are not required to infer a particular intent from the defendant's conduct or statements, but it is an inference that you may draw if you find that it is reasonable and logical. I remind you again, the burden of proving intent beyond a reasonable doubt is on the state. Evidence of motive, or the lack of it, may also be considered by you in determining the issue of intent. You will refer to the court's instruction on motive below. Motive. The law does not require that the state in a criminal case prove a motive because it is not an element of a crime. It is not necessary for the state to prove what reason the defendant may have had for committing a crime charged. Because crimes are generally committed for some motive, evidence of a motive may tend to prove the guilt of a defendant. In the same manner, if there appears no adequate motive on the part of the defendant to commit the crime, that may tend to raise a reasonable doubt as to the guilt of the defendant. If the existence of a motive can be reasonably inferred, that may tend to prove the defendant's guilt. If no motive can be inferred, it may or may not raise a reasonable doubt as to the guilt of the defendant. If the absence of a motive does not raise a reasonable doubt that the defendant is guilty, then the fact that the state has not proved what the defendant's motive was does not prevent you from returning a verdict of guilty. Consciousness of guilt. In any criminal trial, it is permissible for the state to show that conduct or statements made by a defendant after the time of the alleged offense may have been influenced by the criminal act. That is, the conduct or statements show a consciousness of guilt. For example, flight, when unexplained, may indicate consciousness of guilt if the facts and circumstances support it. Such acts, however, do not raise a presumption of guilt. If you find the evidence proved and also find that the acts were influenced by the criminal act and not by any other reason, you may but are not required to infer from this evidence that the defendant was acting from a guilty conscience. The state claims that the following conduct is evidence of consciousness of guilt: the defendant's disposing of the knife, the defendant's denial of his involvement in text messages to his girlfriend, and the defendant's flight from the jurisdiction of Florida. It is up to you as judges of the facts to decide whether the defendant's acts, if proved, reflect a consciousness of guilt, and to consider such in your deliberations in conformity with these instructions. Identification of the defendant. The state has the burden to not only prove every element of a crime, but also the identity of the defendant as the perpetrator of the crime. You must be satisfied beyond a reasonable doubt of the identity of the defendant as the one who committed the crime, or you must find the defendant not guilty. If you have a reasonable doubt as to the accuracy of the identification, you must find the defendant not guilty.
Instructions have gone 32 minutes so far.
Specific charges brought by the state. I will now turn to the specific offenses charged in this case. The substitute information in this case contains 4 counts against the defendant. In other words, the state charges the defendant with committing 4 separate offenses or crimes. You are to consider only the specific charges submitted to you and not concern yourself with how the information may have read when it was read to you at the start of trial. Please note, you will also be instructed to consider lesser included offenses where applicable. Additional instructions on your consideration of lesser included offenses will be provided further along in this charge as it concerns your deliberations on each count. The defendant is entitled to and must be given by you a separate and independent determination of whether he is guilty or not guilty as to each crime charged in each count, including lesser included offenses, if applicable, as instructed in accordance with this charge. Each of the 4 counts charged in the information, including lesser included offenses where applicable, sets forth a separate and distinct crime. The state is required to prove each element of each crime charged in a count, including lesser included offenses, beyond a reasonable doubt. Each crime charged under each count, including lesser included offenses where applicable, must be deliberated upon separately. Please note, the total number of counts charged in the information does not add to the strength of the state's case. You may find that some evidence applies to more than one count in the information or more than one crime under a count. The evidence, however, must be considered separately as to each element of each crime deliberated upon. Each count is a separate entity. You must consider each count separately, including lesser included offenses as instructed, and return a verdict, a separate verdict, for each count. This means that you may reach opposite verdicts on the 4 different counts. A decision on one count does not bind your decision on any other count. I have previously instructed you and herein reiterate. The substitute information is not evidence, it's merely a paper statement of the charges against the defendant, on which the state proceeds to trial. You must not consider it as any evidence of the guilt of the defendant or draw any inference of guilt of the defendant from the substitute information. You will first deliberate on count 1, and then follow the order of deliberations as provided by the court in these instructions. So you're going to proceed to the court's instruction on count 1, murder. Statutory title, which is immediately below. 1. Count 1 murder, Connecticut General Statutes, Section 53A, 54A, subsection A. The state charges the defendant in count 1 with murder, charging that in the county of Fairfield in the city of Shelton on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the said Raul Valle with intent to cause the death of one James McGrath, did stab and cause the death of the said James McGrath in violation of Section 53A-54A, subsection A, of the Connecticut General Statutes. The statute defining the offense of murder reads in pertinent part as follows. A person is guilty of murder when, with intent to cause the death of another person, he causes the death of such person. For you to find the defendant guilty of this charge, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, intent to cause. The first element is that the defendant specifically intended to cause the death of James McGrath. There is no particular length of time necessary for the defendant to have formed the specific intent to kill James McGrath. A person acts intentionally with respect to a result when his conscious objective is to cause such result. Murder is a specific intent crime, and you will refer to the court's earlier instruction on specific intent. The intent to cause death may be inferred from circumstantial evidence. You will refer to the court's earlier instruction on direct and circumstantial evidence. The type and number of wounds inflicted as well as the instrument used may be considered as evidence of the perpetrator's intent, and from such evidence an inference may be drawn that there was an intent to cause death. Any inference that may be drawn from the nature of the instrumentality used and the manner of its use is an inference of fact to be drawn by you upon consideration of these and other circumstances in the case in accordance with my previous instructions. Such inferences are not necessary, but they are inferences you may draw if you find they are reasonable and logical and in accordance with my instructions on circumstantial evidence. Declarations and conduct of the accused before or after the infliction of wounds may be considered if you find they tend to show the defendant's intent. This inference is not a necessary one, that is, you are not required to infer intent from the defendant's alleged conduct, but it is an inference you may draw if you find it reasonable and logical and in accordance with my instructions on circumstantial evidence. Element 2, cause of death. The second element is that the defendant, acting with the intent to cause the death of James McGrath, caused the death of James McGrath. This means that the defendant's conduct was the proximate cause of James McGrath's death. I'm going to refer to the court's earlier instruction on proximate cause. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, for the crime of murder, the state must prove beyond a reasonable doubt that 1, the defendant intended to cause the death of James McGrath, and 2, in accordance with that intent, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of the offense of murder, you shall find the defendant not guilty of the crime of murder and shall then next move on to consider lesser included offenses to murder below in the manner and order therein instructed therein. Proceed to the court's instruction on lesser included offenses to murder below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of murder, you shall next consider the defendant's claims of self-defense and defense of others. You'll refer to the court's instruction on self-defense and defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved beyond a reasonable doubt one of the statutory disqualifications, you shall reject the defenses and find the defendant guilty of murder in violation of Connecticut General Statute, Section 53A-54A, subsection A at count 1. Please note, the state in proving statutory disqualifications has to prove the statutory disqualifications also beyond a reasonable doubt. This will end your deliberations on count 1. You will not deliberate lesser included offenses to murder. You will now deliberate on count 2. We'll skip over the court's instruction on lesser included offenses to murder and proceed directly to the court's instruction on count 2, assault in the first degree intentional below. If, however, you unanimously find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, but on the strength of the defenses alone, you must find the defendant not guilty of murder at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations on count 1. You will now deliberate on lesser included offenses to murder. You will now deliberate on count 2. You will skip over the court's instruction on lesser included offenses to murder and proceed directly to the court's instruction on count 2, assault in the first degree intentional below. Lesser included offenses to murder. In accordance with the court's previous instructions, you will consider lesser included offenses to murder under this section if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of murder and therefore have found the defendant not guilty of murder. The defendant at count 1, the substitute information, is specifically charged with the crime of murder. The offense of murder under our penal code is such that it may include the elements of the crimes of manslaughter in the first degree intentional and manslaughter in the first degree reckless. This brings into play the rule of law known as lesser included offenses. You will consider lesser included offenses to murder in the order and under the circumstances set forth herein. The fact that I am instructing you on lesser included offenses should not be interpreted by you that I believe the evidence proved the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case, and you must determine whether the defendant is guilty beyond a reasonable doubt of murder at count 1 or is guilty of any respective lesser included offense. You will first consider the lesser included offense of manslaughter in the first degree intentional. Connecticut General Statute, Section 53A, 55A1, directly below at subsection A. We proceed to the court's instruction, subsection A, manslaughter in the first degree intentional, the statutory reference directly below. Subsection A, manslaughter in the first degree intentional, Connecticut General Statute, Section 53A, 55A1. Statute defining this offense reads in pertinent part as follows. A person is guilty of manslaughter in the first degree when, with intent to cause serious physical injury to another person, he causes the death of such person. For the defendant to be found guilty of this charge, the state must prove the following two elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. First element is that the defendant specifically intended to cause serious physical injury to another person. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as a physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. You will note that the basis of the charge under this statute is not that the defendant intended to kill, but that he intended to inflict serious physical injury. A person acts intentionally with respect to a result when its conscious objective is to cause such result. Refer to the court's earlier instruction on specific intent at 15. The intent to cause serious physical injury may be inferred from circumstantial evidence. Refer to the court's earlier instruction on evidence of intent at 17. Element 2, cause death. The second element is that the defendant, acting with the intent to cause serious physical injury to a person, caused the death of a person. This means that the defendant's conduct was the proximate cause of the decedent's death. Refer to my earlier instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, the state must prove beyond a reasonable doubt that 1, the defendant intended to cause serious physical injury to James McGrath, and 2, in accordance with that intent, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of manslaughter in the first degree intentional, you shall find the defendant not guilty of manslaughter in the first degree intentional at count 1, and you shall next consider the lesser included offense of manslaughter in the first degree reckless. Proceed to the court's instruction B, manslaughter in the first degree reckless, Connecticut General Statutes, section 53A, 55A3 below. If, however, you unanimously find the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the first degree intentional, you shall not consider any additional lesser included offense. You shall, however, consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of manslaughter in the first degree, intentional, in violation of Connecticut General Statutes, section 53A, 55A1 at count 1. This will end your deliberations at count 1. You will next deliberate on count 2. Proceed to the court's instruction. Count 2, assault in the first degree intentional, Connecticut General Statutes, 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of manslaughter in the first degree intentional in violation of Connecticut General Statutes 53A, 55A1 at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 1. You will not consider any additional lesser included offenses to murder. You shall skip over the court's instructions at subsection B below and next deliberate on count 2. B, manslaughter in the first degree reckless, Connecticut General Statutes 53A, 55A3. You will deliberate on this lesser included offense to murder if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of murder, and therefore you have found the defendant not guilty of murder. And further, you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of manslaughter in the first degree intentional, and therefore you have found the defendant not guilty of manslaughter in the first degree intentional. The statute defining this offense reads in pertinent part as follows. A person is guilty of manslaughter in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a grave risk of death to another person and thereby causes the death of another person. For the defendant to be found guilty of this charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1. Conduct creating a grave risk of death. The first element is that the defendant engaged in conduct that created a grave risk of death. Element 2 is recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You'll refer to the court's previous instruction on recklessness at 16. Element 3, extreme indifference to human life. The third element is that the defendant's conduct demonstrated an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. Then element 4, cause of death. The fourth element is that the defendant's conduct caused the death of James McGrath. This means that the defendant's conduct was the proximate cause of the decedent's death. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a grave risk of death. 2, the defendant acted recklessly. 3, he acted under circumstances evincing an extreme indifference to human life. And 4, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of manslaughter in the first degree reckless, you shall find the defendant not guilty of manslaughter in the first degree reckless to count 1. This ends your deliberations at count 1. You shall next move on to deliberate on count 2. And proceed to the court's instruction on count 2, assault, first degree intentional, Connecticut General Statute 53A, 59A1 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the first degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of manslaughter in the first degree reckless in violation of Connecticut General Statute 53A, 55A3 at count 1. This will end your deliberations at count 1. You shall move on to deliberate on count 2. Proceed to the court's instruction on count 2, assault, first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, after considering the defenses, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of manslaughter in the first degree reckless at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 1. You shall move on to deliberate on count 2. You'll proceed to my instruction on count 2, assault in the first degree intentional, Connecticut General Statute, section 53A-59A1 below. All right, I'm going to give you a few minutes to stand up and stretch. We're going to take a short break. So I'm going to take a 10-minute break right now, give you some time to go back into the deliberations. And again, you can't talk in the middle of the charge. You're not allowed to deliberate yet. Court stands in brief recess. We're going to be back in 10 minutes.
All right, they're going to come back in just a minute. Let me tell you, we're going to start a little poll really quickly that you might find interesting. This is specifically to the first charge because we've already passed the instructions on the first charge. We now just have the 3 injury, or the charges related to the injuries. The first one has to do with death. So we have a question we're putting up here. The question is, I'll read it to you, then I'm going to post it. So I don't want you to choose too rapidly because there's some very subtle changes in the answers here. On the first charge, this relates to Jimmy McGrath. How would you vote as a juror? The first option is not guilty, and I put in parentheses self-defense because the defendant has admitted to through his lawyer, they basically stipulated to the other facts that he was holding a knife, he'd stabbed the guy, and he died. the jurisdictions there, everything. All the other facts are admitted to, so it would just be the self-defense. So not guilty would be self-defense. Option 2 is guilty of murder. That's as charged. Okay, that's the higher charge that he's facing right now. Then we've got 2 lesser includeds on this one. We have guilty of manslaughter intentional. That means he intended to do harm, but it ended up in him Jimmy dying after only intending to harm him. And the 4th one is guilty of manslaughter reckless, which is that he intended to do harm, or no, that he was reckless and it resulted in death. It wasn't. That's the unintentional on that one. Sorry, I answered incorrectly. So that poll's going up right now. That would be interesting to see where you guys stand on this one. It is up as we speak. Lizzie, by claiming self-defense, it inherently includes an admission to the other elements of the charge. It's saying, I did it in self-defense. And so this is, I'm talking about the legal side. If you're looking at the terminology he used while he took the stand, yeah, he did avoid a lot of the direct terminology that would associate him with guilt. But from a legal standpoint, claiming self-defense admits to doing it, but says you're justified. So, good point, good question there. Karen G says, poll is equally divided among the 2 that I'm kind of on the fence with. Yeah. Amy, this is a great idea for a poll. Thanks for posting it up there. I wasn't going to wait till the end of this. I do think that this case all hinges on the incident with Jimmy. I think that there is a much higher likelihood that this jury will find that the first 3, or the 3 injuries of stabbings could be self-defense. Those are much easier to deal with because you've got a scenario where you've got many versus one fight actively taking place. We've got testimony from the people who participated in the fight that they threw the first punch, that he was on the ground. They were kicking him, they were stomping on him, they were punching him, and that makes sense. It's easier for a jury to say, okay, clearly, yeah, that he's fighting for his life there. It's different with Jimmy. First of all, we don't have video. That exact moment happens out of frame, so we don't know if the fight continued or not. But the testimony from most of the people on the scene says Jimmy didn't do anything. And that's going to be hard to overlook, I think, for the jury, especially because Jimmy is no longer with us. So, can someone see how you see this as self-defense? It really depends on who you believe, and unfortunately, everybody who participated in this trial, except for a couple doctors, I think, answered in shady ways in one way or another, which would give me as a juror reason to disbelieve part or all of their testimony. I think the part from most of the witnesses that the state offered, where they just didn't recall key elements about who everyone else was and who had done anything, and if they had attacked the car or anything else. That part was really shady, where they all got to the I don't recall part. That makes me doubt some of their testimony. A lot of them said, I wouldn't do anything that would get my friends in trouble or make cast a negative pale over the name of Jimmy McGrath and the memory of him. Well, you want him to look good, but he may have been involved. I mean, he was in an area where other people who were involved in the fight were, and he was leaving with them. As you know, it's possible that he was involved just because it wasn't caught on video. I don't know. So I see there's a possibility, looking at the law in not South Dakota, you said self-defense. The law in Connecticut, it does require that you retreat if possible. The testimony was that he couldn't retreat, and that everyone was climbed on top of him, were hitting him, kicking him, surrounding him. I think that checks that box. The retreat was not an option. That he was in fear for his life. He testified that he was. A reasonable person may be in fear for their life. He lost consciousness, came to, and claims he was still being attacked. So I think that part's there. I think there are elements of jury, depending on what they believe, could see that way. What do you mean no intent? He had a knife. Having a knife is not intent. He could have a gun, and that's not intent. Remember, nobody at the scene. The only people that said that he saw the knife before the fight was right when he says it was thrown to him out of the car by the driver, by Jack. Jack throws him a knife. He's like, "What's this for?" He's all confused. He's like, "Just in case." He's like, "Whatever," and he sticks it in his pocket. That's when one person says he saw the knife with Raul. It wasn't when the people came running down and sprayed him in the eye with WD-40, which the state admits to. It wasn't when they went back. He didn't have it out when he went back and they were talking. He was asking for the one person he knew, Ayden King or whatever his name was. And it wasn't then. He didn't have it out then. So I would argue that having a knife means nothing as far as intent goes when he was not fighting. There was no intent to fight. So just having a knife and using it in self-defense, I think they could argue that. It was Jack's knife. Yep, the driver had it. All right. Was there any expert testimony? No. On the depth of 4 knife wounds? No. None of them. I don't even remember hearing from the medical examiner. We heard from the doctors. Well, there might have been an ME. I don't recall. Did we hear from an ME or was it just a doctor? Okay, we're gonna go back here to court here in just 1 second. Hold on. They're coming back. We did hear from the ME. I know that the knife wound to the chest for Jimmy did rupture his heart. But it doesn't take, I mean, an 1.5-inch blade can do that with a strong punch. His was 3.1 inches, if I remember correctly.
Your Honor, just one on one.
Yeah, we'll wait on. Thank you.
Waiting on one juror. He obtained the knife after the fighting started. It was given to him, but he kept it in his pocket. He didn't bring it out until after he'd been attacked.
I'll set Your Honor.
Thank you. Okay. All right, welcome back, ladies and gentlemen of the jury. I want to thank you for your patience during the reading of these instructions. I know that it's a long time to be seated, so thank you for your attention. Counsel, please stipulate to the return of our jurors.
State will stipulate, Your Honor. Defense stipulates, Your Honor.
All right, thank you so much. I'm going to continue. So I'll be continuing with count 2. Assault in the first degree intentional, Connecticut General Statutes 53A, 59A1. State charges the defendant at count 2 with assault in the first degree, charging that in the county of Fairfield, city of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the defendant with intent to cause serious physical injury to one Ryan Hines would cause serious physical injury to the said Ryan Hines with a dangerous instrument, to wit, a knife, in violation of Section 53A, 59A1 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when, with intent to cause serious physical injury to another person, he causes such injury to such person or to a third person by means of a dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. The first element is that the defendant intended to cause serious physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. You refer to the court's earlier instruction on specific intent. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by a statute as physical injury which creates, a substantial risk of death, or which causes serious disfigurement, serious impairment of health, or serious loss of impairment of the function of any bodily organ. Element 2, cause serious physical injury. The second element is that acting with that intent, the defendant caused serious physical injury to Ryan Hines. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's earlier instruction on proximate cause. We must find it proved beyond a reasonable doubt that Ryan Hines was seriously injured as a result of the actions of the defendant. It does not matter whether Ryan Hines was the person upon whom the defendant intended to inflict serious physical injury. It is sufficient if you find that the defendant intended to cause serious physical injury to another person, and that he in fact caused serious physical injury to that person or to some other person. Element 3, with a dangerous instrument. Third element is that the defendant caused that injury by means of a dangerous instrument. Dangerous instrument means any instrument, article, or substance which under the circumstances in which it was used or attempted or threatened to be used is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had that potential under the circumstance. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause serious physical injury to another person, the defendant did cause serious physical injury to Ryan Hines, and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree intentional, you shall find the defendant not guilty of the crime of assault in the first degree intentional at count 2, and shall move on to consider lesser included offenses to assault in the first degree intentional below, in the manner and order prescribed therein. You will proceed to the court's instruction on lesser included offenses to assault in the first degree intentional under the section below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, you shall next consider the defendant's claims of self-defense, defense of others. Refer to my instruction on self-defense, defense of others below at 23. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, then you shall reject the defenses and find the defendant guilty of assault in first degree intentional in violation of Connecticut General Statutes 53A, 59A1 at count 2. This will end your deliberations at count 2. You will not consider lesser included offenses. You will move on to deliberate count 3. So you'll skip over lesser included offenses to assault in the first degree intentional below and proceed directly to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defense alone, you shall find the defendant not guilty of assault in the first degree intentional at count 2. Even though you have found the elements of the crime of assault in the first degree intentional proved beyond a reasonable doubt. This will end your deliberations as to count 2. You shall then move on to deliberate count 3. You will skip the court's instruction on lesser included offenses to assault in the first degree intentional below and proceed directly to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. Lesser included offenses to assault in the first degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses under count 2 if and only if you have unanimously found If the state has not proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, and therefore found the defendant not guilty of assault in the first degree intentional at count 2. The defendant at count 2 information is specifically charged with the crime of assault in the first degree intentional. The offense of assault in the first degree intentional under our penal code is such that it may include the elements of the crimes of assault in the first degree reckless and assault in the second degree, both intentional and reckless. This brings into play a rule of law known as lesser included offenses at count 2 as applicable to the crime of assault in the first degree intentional. You will consider lesser included offenses as to count 2 in the order and under the circumstances instructed herein. The fact that I am instructing you on lesser included offenses to assault in the first degree intentional at count 2 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offenses. You, the jury, are the sole judges of the facts of this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the first degree intentional or is guilty of any respective lesser included offense. You will first consider the lesser included offense of assault in the first degree reckless directly below. Proceed to the court's instruction A, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3 directly below. A, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a risk of death to another person and thereby causes serious physical injury to another person. For you to find the defendant guilty of this charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a risk of death. The first element is that the defendant engaged in conduct that created a risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result of circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. They refer to the court's previous instruction on recklessness at 16. Element 3, extreme indifference to human life. The third element is that the defendant acted under circumstances evincing an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, caused serious physical injury. The fourth element is that the defendant caused serious physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Ryan Hines was injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury, which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or a serious loss or impairment of the function of any bodily organ. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a risk of death, 2, he acted recklessly, 3, he acted under circumstances evincing an extreme indifference to human life, and 4, he caused serious physical injury to Ryan Hines. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree reckless, you shall find the defendant not guilty of assault in the first degree reckless at count 2, and you shall then consider the lesser included offense of assault in the second degree intentional. You'll proceed to the court's instruction on B, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2 below. If, however, you unanimously find that the state has proved, beyond a reasonable doubt, all the elements of the crime of assault in the first degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree reckless in violation of Connecticut General Statutes 53A, 59A3 at count 2. This will end your deliberations at count 2. You shall not consider any other lesser included offense at count 2. You will skip the court's instructions in subsections B and C below and shall next move on to deliberate on count 3. We'll proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the first degree reckless at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 2. You shall not consider any other lesser included defenses at count 2, included offenses at count 2. You will skip the court's instructions at subsections B and C below. You will move on to deliberate on count 3. You'll proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below.
Okay, we're over halfway done. We'll do these charges part.
Still under lesser included offenses, B, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2. You will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore have found the defendant not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless at count 2. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he causes such injury to such person by means of a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove beyond a reasonable doubt 3 elements. Element 1, intent to cause physical injury. The first element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. You will refer to the court's previous instruction on specific intent at 15. Physical injury is defined as impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious. It may be minor. Element 2, caused physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. You must find it proved beyond a reasonable doubt that Ryan Hines was injured as a result of the actions of the defendant. You will refer to the court's previous instruction on proximate cause at 14. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to that person or to some other person. Element 3, with a dangerous instrument. Third element is that the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that, in fact, death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person. 2, the defendant did cause physical injury to Ryan Hines. And 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, You shall find the defendant not guilty of assault in the second degree intentional at count 2, and you shall then consider the lesser included offense of assault in the second degree reckless. You'll proceed to my instruction on C, assault in the second degree reckless, Connecticut General Statutes 53A 68.3 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, then you shall next consider the defendant's claims of self-defense and defense of others. You will refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree intentional in violation of Connecticut General Statutes 53A 68.2 at count 2. This will end your deliberations at count 2. You shall not deliberate on any other lesser included offenses. You shall move on to deliberate count 3. Proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A 59A A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, and on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree intentional at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 2. You shall not consider any other lesser included offenses at count 2. You shall then move on to deliberate count 3. You will skip subsection C below and proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A 59A1 below. Still on lesser included defenses, C, assault in second degree reckless, Connecticut General Statute 53A 68.3. You will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore you have found the defendant not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the second degree intentional, and therefore have found the defendant not guilty of assault in the second degree intentional. The statute defining this offense reads in part and part as follows. A person is guilty of assault in the second degree when he recklessly causes serious physical injury to another person by means of a deadly weapon or dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, recklessness. The first element is that this defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. Refer to my previous instruction on recklessness at 16. Element 2, cause serious physical injury. The second element is that the defendant caused serious physical injury. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Ryan Hines was injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as a physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element is that the defendant used a dangerous instrument in causing a serious physical injury to another. Dangerous instrument means any instrument, article, or substance which under the circumstances in which it is used or attempted or threatened to be used is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or a serious loss of impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant acted recklessly, 2, the defendant caused serious physical injury to Ryan Hines, and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 2. This will enter deliberations at count 2. You shall next move on to deliberate on count 3. Proceed to the court's instruction. Count 3, assault in the first degree intentional. Connecticut General Statute, Section 53A, 59A1 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statute, Section 53A, 60A3 at count 2. This will end your deliberations on count 2, and you shall move on to deliberate on count 3. You'll proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 2. You shall move on to deliberate at count 3. Proceed to the court's instructions. Count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. Count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1. The state charges the defendant in count 3 with assault in the first degree, charging that in the county of Fairfield, city of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the defendant, with intent to cause serious physical injury to one Thomas Connery Jr., did cause serious physical injury to the said Thomas Connery Jr. with a dangerous instrument, to wit a knife, in violation of Section 53A, 59A1 of the Connecticut General Statutes. The statute defining this offense reads in part and in part as follows. A person is guilty of assault in the first degree when with intent to cause serious physical injury to another person. He causes such injury to such person or to a third person by means of a dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. First element is that the defendant intended to cause serious physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such a result. Refer to my earlier instruction on specific intent at 15. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury, which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Element 2, cause serious physical injury. The second element is that acting with that intent, the defendant caused serious physical injury to Thomas Connery Jr. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to my earlier instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was seriously injured as a result of the actions of the defendant. It does not matter whether Thomas Connery Jr. was the person upon whom the defendant intended to inflict serious physical injury. It is sufficient if you find that the defendant intended to cause serious physical injury to another person and that he, in fact, caused serious physical injury to that person or to some other person. And element 3, with a dangerous weapon or instrument. The third element is that the defendant caused that injury by means of a dangerous instrument. Dangerous instrument means any instrument, article, or substance which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article is capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that, in fact, death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that, 1, the defendant had the specific intent to cause serious physical injury to another person.
Can the summary
2,
be the
the
end?
defendant did cause serious physical injury to another person. 2, the defendant did cause serious physical injury to Thomas Connery Jr. I'm sorry. I'm going to strike the in summary that I just gave. Let me just read through that again. In summary, the state must prove beyond a reasonable doubt that, 1, the defendant had the specific intent to cause serious physical injury to another person. 2, the defendant did cause serious physical injury to Thomas Connery Jr. And 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree intentional, you shall find the defendant not guilty of the crime of assault in the first degree intentional at count 3, and you shall next consider the lesser included offenses, starting with assault in the first degree reckless, proceed to the court's instruction on lesser included offenses to assault in the first degree intentional below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree intentional in violation of Connecticut General Statutes 53A-59A1 at count 3. This will enter deliberations at count 3. You will not consider lesser included offenses. You will move on to deliberate on count 4. Skip the court's instruction below on lesser included offenses to assault in the first degree intentional.
She's going to keep talking. She's literally repeating exactly the first thing we said, because 3 of the charges, the assault charges, 2 of them are identical. She's in the second one, which means we've covered the murder charge, we've covered one of the assault charges, and now we're in the second assault charge. The third charge is going to be a little bit different, so we're going to come back to that in just a minute. I just want to say one thing that is standing out to me, and I apologize, I normally don't talk over this, but it's literally a repeat, and all of you were sleeping. One thing that's standing out to me is something that she's emphasized quite well in this, and that is that the jury is not to consider any of these lesser includeds unless they unanimously agree that the state did not prove the elements of the higher charge, which means the jury has to unanimously agree on not guilty on the higher charge in order to consider the other ones. I realize it's a fine point, but they're not allowed to just say, I don't know, I think they did, you think they didn't, how about a lower charge? Nope, they have to unanimously agree that they did not do that. So that's a little saving grace.
Take a 5-minute recess because I know this is long, okay? Court's going to stand in recess for 5 minutes again. Please do not discuss the case. Court stands in recess.
All right, recess.
We've got 5 minutes. She's not done yet. She just needs another break. She needs the break, I think, at this point, and maybe the jurors are dozing off as well. While we take just a minute on this break, let me just say, first of all, it's a short break. It's 5 minutes. We're not going to go anywhere. we do have the thumbnail up for the podcast tonight. It starts at 8 p.m. We'll actually do a portal over there so you can click the like button and click the notify button so that you'll get notified when we go live. That's up there. It does have a special thumbnail because it's a special podcast. So do check that out. It's gonna be a good one. Many jelly beans will be involved. All right, a couple things. Let me just get the important bits out of here. Specifically regarding the first charge, the lesser included. You've got murder. You've got the murder as the first charge with Jimmy McGrath. They're charging him with murder. If they find that it was not proven as murder, there are two options they can go lesser. One is first-degree intentional manslaughter. That means I tried to hurt him, and he ended up dying. And the other one is manslaughter in the first degree reckless, meaning I behaved in a way that I should have known it would have caused injury or death, and he ended up dying. So those are the two lesser includeds on that one. That I think the jury is probably going to be inclined to do one of those. We do have the poll results that we've put up in chat. I'm going to see if I can post it one more time. Let's see. Because we didn't get a chance to go over it. The poll was complete with about 800 votes in it. And we as a community came up with this, that on the first charge regarding Jimmy McGrath, how would he vote as a juror? 42% said guilty of manslaughter reckless. That is the second lesser included, or the least charge on that element. Then next on not guilty self-defense, 35%. Guilty of manslaughter intentional, 14%, and just 7% found guilty of murder on that first charge with Jimmy. That's how we broke it down. If we are any indication, if we're anything like what's going on in the courtroom, they might have a challenge on their hands. Jury might not be able to come to an agreement. Let's see. She does not want them to deliberate today. She might not get done today. I'm looking at this point. I'm thinking, Judge, you do realize the nation has a birthday to celebrate tomorrow, and at this current rate, we might not be done. Yeah, we're not getting to deliberations tonight. It's I do want to hear what she has to say, but I don't think we're getting to deliberations. Let me go back and play just the audio of just one part. Just 1 second. Different.
Happy birthday. You look good.
Resolve. New project. Nope, that's not it. I'm in the cloud. Okay, go to reopen this. Hang on. They won't start deliberating until Monday after the long weekend. That is crazy. I agree. It is absolutely crazy. Everyone's stretching, walking around, standing up in the courtroom. Poor judge, she has to be tired of reading this aloud. I really wish that they, on charges where everything is the same, Red pen, a little honesty, never hurt anybody, where the charges are identical with two things. You could say, here are the instructions relating to this charge. There are two of them. Work through this process twice. Basically say ditto, right? Save yourself half an hour and say ditto, because there is nothing different about those two. Like, absolutely nothing. They're not even listing the name of the victim. Do you know what the sentence is for manslaughter? Great question, Virginia. Yes, the sentence for manslaughter is up to 20 years for that in Connecticut. That's also there's also a $15,000 fine, and there is a mandatory minimum of 5 years that cannot be suspended, meaning there would be at least 5 years served for that. I think we're back though. Does somebody have some Tic Tacs? Please share with the class. Oh, I've got my own.
through this. I appreciate your focusing your attention. I know this is not easy. Counsel, please stipulate to the return of our jurors.
State will stipulate, Your Honor. Defense stipulates, Your Honor.
All right. I'm going to talk to you now about lesser included offenses to assault in the first degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses under count 3 if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, and therefore you have found the defendant not guilty of assault in the first degree intentional at count 3. The defendant at count 3 of the substitute information is specifically charged with the crime of assault in the first degree intentional. The offense of assault in the first degree intentional under our penal code is such that it may include the elements of the crimes of assault in the first degree reckless and assault in the second degree, both intentional and reckless. Similar to count 2, this brings into play the rule of law known as lesser included offenses.
Sorry, I'm going to mute her while I answer these questions because we've heard all this before. A stipulation means that both sides agree to and they present as true to the court, or that both sides are united on that. So they're both just saying the jury's here.
The fact that I am instructing you on lesser included offenses to assault in the first degree intentional at count 3 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the first degree intentional or is guilty of any respective lesser included offense. You will first consider the lesser included offense of assault in the first degree reckless directly below its subsection A. You'll proceed to the court's instruction A, assault in the first degree reckless, Connecticut General Statutes 59A3 directly below. A, assault in the first degree reckless, 53A, 59A3. Statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a risk of death to another person and thereby causes serious physical injury to another person. For you to find the defendant guilty of the charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a risk of death. The first element is that the defendant engaged in conduct that created a risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstance when he is aware of and consciously disregards the substantial and unjustifiable risk that such result will occur or that such circumstances exist. You'll refer to the court's previous instruction on recklessness at 16.
It's
Element
416
3,
right
extreme
now.
indifference to
416.
human life. Third element is that the defendant acted under circumstances evincing an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, caused serious physical injury. Fourth element is that the defendant caused serious physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. You refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was injured as the result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury. It is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a risk of death. 2, he acted recklessly. 3, he acted under circumstances evincing an extreme indifference to human life. And 4, he caused serious physical injuries to Thomas Connery Jr. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree reckless, you shall find the defendant not guilty of assault in the first degree reckless at count 3, and you shall then consider the lesser included offense of assault in the second degree intentional. We'll proceed to the court's instruction on B, assault in the second degree intentional, Connecticut General Statutes 53A2 below. 53A-16A2 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree reckless, Then you shall next consider the defendant's claims of self-defense and defense of others. You'll refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory exceptions beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree reckless in violation of Connecticut General Statutes 53A, 59A3 of count 3, at count 3. This will end your deliberations at count 3. You will not consider any additional lesser included offenses under count 3. You shall move on to deliberate count 4. You'll skip subsections B and C below and proceed directly to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the first degree reckless at count 3, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 3. You will not consider any other lesser included offenses under count 3. You shall move on to deliberate on count 4, skip subsections B and C below, and proceed directly to the court's instruction on count 4, assault in second degree intentional, Connecticut General Statutes 53A, 60A2 below. B, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2. You will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore you have found that the defendant is not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless at count 3. The statute defining this offense reads in permanent part as follows. A person is guilty of assault in the second degree, but with intent to cause physical injury to another person, he causes such injury to such person by means of a deadly weapon or a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result. When his conscious objective is to cause such result, you will refer to the court's previous instruction on specific intent at 15. Physical injury is defined as impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious. It may be minor. Caused physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injury. You will refer to the court's earlier instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was injured as a result of the actions of the defendant. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he, in fact, caused physical injury to the person or to some other person. Element 3, with a dangerous weapon. The third element is that the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if, under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that, in fact, death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that, 1, the defendant had the specific intent to cause physical injury to another person, 2, the defendant did cause physical injury to Thomas Connery Jr., and 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you unanimously find that the state has failed, if you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of assault in the second degree intentional at count 3. And you shall then consider the lesser included offenses of assault in the second degree reckless. We'll proceed to the court's instruction on C, assault in the second degree reckless, Connecticut General Statutes 53A, 60A3 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, then you shall next consider the defendant's claim of self-defense and defense of others. You'll refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree intentional in violation of Connecticut General Statutes 53A 61-2 at count 3. This will end your deliberations at count 3. You shall not deliberate on any lesser included offenses. You shall move on to deliberate count 4. We'll skip subsection C below and proceed directly to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A 60A2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree intentional at count 3, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 3. You shall not consider any other lesser included offenses, and instead shall move on to deliberate on count 4. You will skip subsection 3 below and proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes, section 53A 60A2 below. C, assault in the second degree reckless, section 53A 60A3. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when he recklessly causes serious physical injury to another person by means of a deadly weapon or dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, recklessness. First element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. We'll refer to the court's previous instruction on recklessness at 16. Element 2, caused serious physical injury. The second element is that the defendant caused serious physical injury. This means that the defendant's conduct was the proximate cause of the defendant's injuries. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was seriously physically injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical conditional pain. It is more than a minor or superficial injury. It is defined by statute as a physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element is that the defendant used a dangerous instrument in causing the serious physical injury to another. Dangerous instrument means any instrument, article, or substance which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means serious physical injury which creates a substantial risk of death or which causes serious disfigurement, creates a substantial risk of death or which causes, creates backup. I'm going to redefine serious physical injury for you, so strike that.
Oh, good. Go back and read it.
Under dangerous instrument, element 3. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be dangerous instrument if, under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. In summary, the state must prove beyond a reasonable doubt that 1, the defendant acted recklessly, 2, the defendant caused serious physical injury to Thomas Connery Jr., and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 3. This will end your deliberations at count 3. You shall next move on to deliberate on count 4. Proceed to the court's instruction on count 4 assault in the second degree intentional, Connecticut General Statutes 53A 60A2 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statutes 53A 60A3 at count 3. This will end your deliberations at count 3, and you shall then next move on to deliberate count 4. You'll proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes section 53A 60A2 below.
I get a bingo if she spills her water.
If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then, on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 3, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 3, and you shall move on to deliberate on count 4. So you will proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A 60A2, immediately below. All right, ladies and gentlemen of the jury, it has been a long day of sitting, and we are about a little over, I would say, 3/4 of the way done with my charge. However, it is 4:30. So I am going to go ahead and I am going to adjourn for the day.
This is terrible.
So what that means is...
This is terrible.
I'll go over this again. You have heard all of the evidence. You've heard closing argument. You've heard part of the jury charge, part of the court's instructions to you that apply in this case. You have not heard all of those instructions, nor have you been told to engage in deliberations. You still remain under the obligation of your oath and your general conduct rules still need to be abided by. So please do not discuss this case. You cannot even discuss it with one another. Please, it's a long weekend. We're not here tomorrow. Tomorrow's July 4th. It is a holiday. So I know this is a little bit longer than I had initially anticipated. Hopefully this is not too much of an inconvenience, and I do apologize to the jury. But July 4th is a holiday. We will next convene on this case Monday, July 7th. So you will come back on Monday, July 7th. I will finish up the jury charge at that time in the morning.
Do we have problems?
So we'll get
on
on the record right at 10, and then you will start your deliberations. All right, so no discussing the case. Again, I can't impress upon you the extent to which this case is being covered in the news, social media, and other outlets. Please do your best to avoid the news, social media, and any other outlets where something like this may be posted. I mean, I can't control your actions, but I am going to ask you to please take this case seriously and your duties relevant to your conduct seriously. Have a fantastic holiday. Have a nice long weekend, and we will see you back here on Monday for the continuation of the trial. Thank you. The court stands adjourned.
Wow. The longest instructions ever. They start on a Thursday, they finish on a Monday. This is terrible. I know it's going to feel like she read them all weekend long. this is absolutely terrible. I don't do this often, but Connecticut, you're doing something wrong. Something is wrong in the system with you. And I realize the jury instructions are crucial for the jury to get it right. And the jury instructions are crucial for the preservation of the rights of the defendant. But I think you can do better with less words. Fewer, I guess, with fewer words. That way, Red Pen won't get mad at me. Wow. Yes. I don't know. Caffeine injections will be offered on Monday, I'm guessing, for the juror members because holy long instructions. We've got 4 charges. The only time we've seen longer instructions than this was with Daryl Brooks. And he had, 97 charges against him? 97 counts? It took hours and hours for that one. We have 4. 4 here, with lesser includeds, but 4, and it should be a lot faster. All right, good news. We're almost to the podcast. The judge took that long, and so we do have a podcast. I've actually got the thumbnail created. It's a new thumbnail. Please check it out. I'm very proud of it. It's not fancy, but it will tell you exactly what's coming up in the podcast. On the podcast, we are giving away memberships. Yes, we give away gifted memberships the first podcast of each month. That's something YouTube gives me to give you, and so we're going to do that. Be here early for that. We like to get it to give them away when the most dedicated people are present, which is usually early on in the podcast. So be here for that if you're looking for one of those. Oh, we're getting a call. Just 1 second. Oops. And I hung up on it. So there was that. Let's see. Just got word that Nicole Goodman is going to be there for sentencing for Brian Koberger. That'll be awesome to check in with her on that. That's going to be on the 23rd of this month. It's a very colorful thumbnail. Yes, it's very colorful. That's not going to happen, Virginia. That's not going to happen. I can assure you it won't happen on screen. I can't assure you it won't happen. These flavors are yucky. Ari needs to give giveaways before he faints from the snacks. We're working on that. Mrs. Ari is a big fan of me cleaning up my desk, and I have a few things that I don't need anymore, like a Lexus 570 right rear taillight. I'm not sure if any of you want that, but maybe that could be something we give away. I know it's going to cost me an arm and a leg to ship it because it's expensive and big. Iris says, I've been away for a few days. How is the Mrs. and family doing? How are y'all doing? Missed you. What will we watch next? We're doing well. Mrs. R.A. crashed the car today. That's a sad thing, but she's all right. The kids are all right. The groceries are all right. The pole's all right, but the car is damaged. And I get to go and see if I can just hammer on it a little bit and sort of get the original shape back, and then we'll decide what to do with the repair. We generally buy our cars used for this very reason. I don't think we've ever purchased a car new from a car dealership. First of all, somebody's calling. Hang on.
From Josh Hutchins.
Oh, Josh, the birthday boy, our moderator. How are you doing, my friend?
What's up, my friend? How you doing?
Well, I was going to go back and replay some of the part from the judge here the last little bit because I think I missed a few things. Just want to make sure.
I'm just glad you didn't retire the birthday song. I appreciate that.
That was a joke, just to get you upset. But so excited to get to celebrate your birthday and sing to you on your actual birthday. So, how has your birthday been?
Good. I've been in here all day, so Well,
excellent, and you've been doing good work.
Yeah, appreciate that. So Happy birthday. I'm dedicated, so I've been here. So.
Yeah, it's been awesome.
The real party starts, later.
It does.
8 o'clock.
Yes, 8 o'clock tonight on this channel. We've got. It's not just all jelly beans. We have some fun news stories to share with you. We've got some fun conversation. It's done live in front of a live studio audience, you guys. So please be here, and your commentary and participation makes it all the much better, all the more better, muchly.
Anyway, I just wanted to call in and tell everybody thank you for the birthday wishes. So.
Well, Josh, thank you. I hope it's fabulous, and I hope whatever happens between the hours of 8 and 9 p.m. tonight doesn't ruin whatever happened previous to that.
Oh, it's going to be bunches of fun, so
Awesome.
I'll be there.
Awesome. Thanks, Josh. Good to hear you.
All right. Have
We'll
a
see
good
you.
one.
You
All
too.
right, bye.
Bye. That's Josh Hutchins, our great moderator who does a great job. And usually the one that gives us our birthday list in the morning, and he happens to have a birthday this morning. The jury is not deliberating now. The timer has not started. The instructions are not over. Can you believe it? It's been a long time. She talked for nearly 2 hours, and she's 3/4 of the way through, which means we've got about 40 minutes or so left. Yeah. It's going to be crazy. Did she back into a pole? If so, it was in the way. Yes, that's pretty much how it happened. She was picking up the order of groceries at Walmart and was backing out, checking behind her, and turned the wheel a little too soon and hit one of those big yellow poles. So, yeah, it happens. She's all right, though. And cars can be replaced. It's people that matter.
Call from Amy Mancy.
Amy, the suggester of great polls today. How are you doing today?
Hey, I'm doing just fine. Hanging out with my grandson.
Awesome.
We
Didn't
had
have a
little
grandson when the
sleepover.
instructions started. That's...
Yeah, yeah, exactly. Holy cannoli. That's why I was like, let's break up the monotony.
Yeah.
Let's do a poll in the middle of this.
That was awesome. What's on your mind?
I said I would call when we were all done. I'd call back, and so I'm calling back. And, yeah, I just wanted to give some food for thought. We all have to remember that these were teenagers. I mean, the prosecuting attorney drove me crazy with his size while the defense attorney was doing his closing, and I'm not in agreement that we have a set of adults and a set of teenagers. They all are prefrontal cortex undeveloped, young, testosterone-driven men.
That's
and
pretty good,
football
pretty
players
fair
to boot.
description of what we had going on there, I think.
Yeah, I mean, it is what it is, and it's just something to think about. I mean, when they all sat there and testified, they all looked quite a bit older than they were, but they still don't have their prefrontal cortex developed, any of them. Yeah. And when that's the case, you're very impulsive, and you don't think straight, and you do stupid things. I personally, I never mind if chat chews me up, so it's okay.
Oh, you're good.
When you get to the assault charges, well, I'll just say, the reason I asked you to do the murder poll was I was curious where everybody was sitting with it. And I'm in the boat of the manslaughter, the reckless. I think that's the third one, right?
Yes.
Which one was the highest in the poll? Yeah. He did kill somebody, and that's unfortunate. And he's not going to get out of that. Somebody's dead. And I think he already knows. If his lawyer is as good as everyone says, his lawyers told him, you're going to go to jail for a while. And I think he made that point when he did his rebuttal, and asked him, did you kill him? Did you, and I think that was on purpose. I know you made the comment you were disappointed in his rebuttal, but at that point, the prosecutor had worked so hard to get him to give a yes answer to did you do it? Mm-hmm. And he finally got the yes, and that's when the prosecutor was pretty well done.
Yeah.
How do you rehabilitate anything once the prosecutor worked that hard and he finally caved and said yes? So I think that
The prosecutor was asking the question differently, though. He was saying, "That's when you turned and stabbed him in the chest," and he says, "No." And he's like, "You didn't. It wasn't. You didn't see the injury on his chest. That wasn't your knife that did that." He's like, "It was, but I didn't turn and stab him in the chest," is what he was trying to say. And I think the jury saw that the prosecutor wanted him to say yes to the prosecutor's version of how it happened.
I would have seen that. And when they tell you to strike it from your notepad, it's too bad. It's in your brain already. How do you just knock that out of your brain? It's nearly impossible. I mean, if we could reboot every time like a computer does, that'd be great. Delete that line, you know. Yeah. And we just can't. So I felt like the defense attorney was appropriate in allowing Lito to say, yeah, I did it. Yes, I understand. And I know I'm going to get something out of this, you know?
Yeah.
I'm going to take this much responsibility. On the assault ones, you know, I agree. You can't. He had the knife. I think he was trying to defend his buddies. I think that he probably wasn't. Jimmy McGrath was in the wrong place at the wrong time. And so was Mr. Valle.
Yeah, I think they all were. I think that scenario, underage drinking, parties with just people just showing up, this is the wrong place to be. Bad things happen there. Things get out of control. Things get out of hand. They were all in the wrong place. Does that mean anyone was, should have been stabbed? No. Does that justify that? No. It's just there were there's a whole row of bad decisions that led to this, and we're trying to pin the blame for the outcome on the very last bad decision, and I think.
Right. I mean, Mr. Valle made a bad decision starting when he headbutted the kid with the helmet on. Mm-hmm. And I thought when I saw that picture of him with the neck pillow and the helmet on, how much shorter he was than the other guy, and how much younger he was in comparison to some of those kids. And he's probably the joker of his friend group, the one that is the goofy guy or whatever. And so then they kick these kids out who get ticked off, who go to the other party, and those guys are like, ooh, let's just tell them all to come here. We'll teach them a lesson. They're not going to get away with headbutting you. I mean, they egged him on a little, and I don't know if you guys noticed, but Mr. Valle, in the picture of him with the football helmet and the neck pillow, he had a bottle of liquor.
It was like, what's it called? It's like Skanky or something. Somebody tell me what the name was. Skimpy, Slinky.
Yeah.
That blue. He had a blue and pink, right? He had the blue one.
Right. I don't know what it is either because I don't drink. And
Kinky,
so
kinky. I was close.
Skanky,
clinky, kinky. It's about the same thing. Bottle of kinky.
I'll have to look that up.
He might have had some skanky too. I'm not saying. I withdraw that.
Well, I was going to say he maybe was hoping for some skanky, but anyway, I'll withdraw that as well.
We'll wrap it up here.
I'll stop it there. But so for him, this was more than 2 beers. He was, under the influence of actual liquor. And my guess is that the other guys were drinking it in the car. This isn't a 2-beer situation. No. This is more than that. And it's unfortunate. So I was not surprised at the manslaughter, the third charge. I get them all confused, so I'll just say the third one in your poll. For me, I think that's appropriate. Reckless. Yeah, he was reckless. And on the assault charges, he's got a dangerous weapon in his hand. And I think you get to a point well, I don't, because I'm not the fighter person, but I have seen other kids get into situations where they just don't stop.
Yeah.
You know, it's boys, and it's hormones, and it's liquor, and they just didn't know when to stop. Yeah. And
I look at this and it's sad. The more I look at it, the more we talk about it, just the sadder it gets, honestly.
It's what?
It's sad. There are no winners here. Even at the end of the day, it just there's more and more loss, more losing going on. And I look at this and say, what can we learn? What can we draw from this, and how can we make the future better because of what we've had to go through with this one?
Right.
Sadly, I think some
I
people
sat
don't get much of a future choice, right? Obviously, Jimmy McGrath's family and Jimmy himself, his future was decided that night, and the family has to deal with
exactly.
that.
Yeah. I sat on Wednesday, at the end of the day, I was, like you said, I was sad. I mean, I was dang near ready to just cry because that prosecutor had chewed on him long enough, and then his lawyer came up and said, you know, you did this, and I was just kind of sighed like the prosecutor does, and she's out there. Will you go find her? I'm sorry, we lost the dog.
Okay, you need to go find the dog. Yeah.
No, my grandson went to look. She's in the yard somewhere. Okay. And I just was sad. I was just like, that sealed it. He's for sure going to spend some time. It's a matter of what. I mean, I think we all knew he was going to spend some time. Mm-hmm. It's just a matter of what they decide. And I don't think they're going to come back quickly. I'm hoping that they'll take their time.
Well, if they have to read any of the instructions, it's going to take another day. Just right there.
Exactly.
Because they have to find the part, they have to read it, and they have to understand it, and that's basically 3 hours, 4 hours right there. We're going to have to wrap it up here tonight. We've got I've got some things I have to do before the podcast. So, any other thoughts you wanted to share?
No worries. I want to say one other thing.
Yeah.
Yesterday, when Mrs. R.A. came on after the BK hearing, and she made her comments, and she said that the lawyer touched his arm and all that. I always remember back to when my son was in a court hearing, and I asked the defense attorney, his attorney, how can you possibly defend people that you know are guilty? No, my son was found not guilty, and that was great. He wasn't guilty. But I said, how do you defend someone who says, yeah, I killed him. And he said that his goal is, even if he knows they're going to be guilty, that he gets them the fairest treatment under the law in regards to what they actually did.
Yeah.
So
that's the right answer, to have fair treatment. And exercise their rights. So, force the state to prove them guilty. That's their right. And if you say they shouldn't get the chance to do that, their crime is so heinous. What if you're next? What if you're next accused of something that you didn't do, and it might be heinous, and people say you shouldn't get the right to exercise that right and force the state to prove it. Them exercising that right protects all of our right. It really does. Yeah. At the end of the day, we have to, if we want it for ourselves, if we ever get falsely accused, we have to allow it for others. So, thank you very much for
maybe that'll help her a little. But we'll talk again maybe after we get a verdict or something. But
probably during instructions still on Monday.
Oh, okay. We can chat again. Yeah. I think that I'll for sure use the information while I'm teaching kids.
Yeah.
I can definitely use it as an example of, hey, this could happen to you.
Yeah.
And that's education for me. So, and them. All right. Awesome. I can't wait to watch you eat those jelly beans later.
What's wrong with you? No, it's going to be fun. Look forward to it. Thank you very much. I can't
wait. All right. Talk to you soon. Bye-bye.
All right. We'll see you. Bye. All right. We're we're done for the day. We're wrapping up. 8 o'clock tonight, we have the podcast, which means I've got a few hours to eat good food and enjoy, not having an upset stomach, and not thinking about terrible flavors that have been in my mouth. So I'm gonna have a bowl of cereal. I'm gonna have some of these delicious chicken and biscuit ranch flavor crackers. I'm just gonna enjoy not having yucky jelly beans in my mouth. But I'm committed. I owe it to Thomas, and I've promised it to you, and I think I owe it to my kids now as well. So, with that said, let's go ahead and wrap this up. We will have no deliberation over the weekend. We can take a break. Obviously, tomorrow's a holiday. No court tomorrow, so we're going to go all the way through after the podcast tonight until Monday. Before we have anything else. So, I'm full confession. I have never in my life had any of these bad jelly beans. I've never tasted a single one. I thought it would be silly for somebody to do that. Now I find myself in a situation where I probably am going to taste one. What do you guys give me if I can do it with a straight face and tell you that every single one tastes like apple pie? Is that a possibility? Is that a possibility? 22, and I'm just like through all of them. Chew, swallow the whole thing. I don't know. I doubt it. I don't think I can do it. I'll give you a like, says Adam Nusky. Thank you. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again tonight at 8 p.m. on this channel, live with the Not Relevant podcast. Please join Thomas and I here. It's going to be a blast. And beans will be consumed. At least 22 of them. The rest of them might end up in the garbage, but 22. That's what I'm going to do. Guys, thank you very much for being here. We'll see you again tonight. It's going to be a blast. All right, bye-bye.
There's nothing in the order that restrains you from talking to cats.
Thank you.
Thank you, sir. You're my new best friend.